Welcome to the School of Thought. This school offers a way to fit into your career, your ambitions, and your schedule. Congratulations on officially beginning your journey. This method may be unfamiliar at first. The focus is to provide underlying principles that will shape the approach to universal law and as it applies to different situations so you can learn different results and identify the factors that led to an outcome. The purpose of this school is to teach you to think like a lawyer. This course of study will cover 9 subjects: civil procedure, constitutional law, contracts, criminal law and criminal procedure, legal method, legal writing, property law, and torts. In addition to watching these videos, you will be required to participate in an exercise in which you must argue a court case in journalism. After completing this course, you will have the opportunity to enroll in further courses based on your specialty or your desire. I encourage you to join organizations in addition to the learning through this course. A good way to continue practice after this course is to manage and edit scholarly journals. Civil procedure is the body of law setting out rules and standards that judges follow when handling civil lawsuits within the judicial branch. In the judicial system, there are allowances where persons can bring criminal prosecution against another person. The person bringing forth the prosecution is called the plaintiff. When reading documents regarding a prosecution, the first name in the versus word is the plaintiff. In this type of system, there is a distinction made between a civilian and a criminal. Evidence from a criminal case can be accepted in a civil case. If the plaintiff shows that the defendant is liable, the remedy of the case is money. This money or award is paid to the plaintiff by the defendant. The standard of proof is lower in a civil case than a criminal case because there is a risk punishing an innocent person. Constitutional law is a body of law defining roles, powers, and structures of entities within the state. The entities of each of the 50 states are similar to the entities of the nation of the United States. There are only 3: the executive, the legislative and the judicial entities. Remember, when dealing with state affairs, it's the entities. With federal or national affairs, it is the branches. The Constitution is a document outlining the basic rights of citizens of the United States of America. This document also identifies a relationship between the central government and the entities that make up the states. All 50 states have what's called a jus commune, which is translated into the law of the land. The law of the land consists of a variety of imperative rules that emphasize consent. Constitutional law is always based on the Constitution, and that is a reference to a document. Constitutional law is the law of the land, and it can be considered as a derivative to the laws themselves. It is a way to exercise power about the way. Human rights and civil liberties are part of the Constitution, as both of them are goals to uphold individuals in the state. Common law and civil law do not exercise the same power as constitutional law. The purpose of the Constitution is to describe procedures of legislation. Constitutional law is the main focus of legal research. The rule of any law is that its government must be conducted according to that law. There are 3 elements to this rule of law. 1. Absolute supremacy is greater than the influence of arbitrary power. 2. Equality always precedes this law. 3. The Constitution is the result of the law of the land. Consider these 3 elements, the 3 tenets. Most lawyers will call them classic due to its nature. Supreme law is another word for regular law and is always greater than arbitrary or discretionary powers. Also know that all persons stand equal in the eyes of the law. Lastly, all general ideas and principles supporting the Constitution are relevant to the judgments preceded and issued by the judiciary, aka the judges who uphold constitutional law. Sitting in the same seat with constitutional law is the separation of powers, and it sits alongside to curb government power. Consider the separation of powers, as I stated earlier, being 3 branches of government: the executive branch, the legislative branch, and the judiciary branch. A contract is a legally binding document between at least 2 parties defining and governing the rights and the duties of the parties to an agreement. These rights and duties are also known as terms and conditions. A contract has four parts. 1. An offer. 2. Acceptance criteria. 3. Considerations of the agreement. 4. Upper and lower boundaries that make mutual intent. When civil law is considered in a contract law dispute, it is considered a branch of the law of obligations. This lesson explains in detail the system of law that is used to govern contracts. Generally, when common law is applied to a contract, there are 5 parts. There is one part that is included with the other 4 stated previously. For the sake of simplicity, I will repeat the 4 and introduce the 5th. 1. The offer. 2. Acceptance criteria. 3. A concrete intention to create a legal relationship. 4. Upper boundaries and lower boundaries to equate to a consideration. 5. A legal structure that consists of both a form as well as content within the form. Not all agreements need to be put into a contract. However, all agreements must have a deem to have some sort or sense of intention to be legally bound. This legal boundary without a contract is called a gentleman's agreement. Like I said, not every agreement needs a contract. However, there needs to be what's called a meeting of the minds, hence the theme of this course.